to the AGBCs.
Yes.
And I'm happy to do that. It's at bundle D2, tab 55, page 182 to 183. The passage starts at the top of page 182. Question: position taken by your former solicitors is that the clients, my clients, and indeed your clients, had signed off on the information Annex 1A. That's right, isn't it? Answer: correct. Presuming the position taken by them was on instructions from you, correct. How did that position come to be taken on instructions from you? His Lordship, is that a matter of privilege? If it is, and then Mr. Brindle gets up, yes, my Lord, the form of the question is privileged. I'm sure it could be rephrased without endangering. Mr. Hill, I'll try again. Thank you, my Lord, you're quite right. And then I put the question again. You must have been aware, weren't you, that this position was being taken? You must have been aware from this position that this position was untrue. And then Mr. Alia says, no, as far as Baker and Mackenzie is concerned, this matter was being handled by the bank's legal team in Zurich, so I'm not really aware of what discussions were being had there. So, perhaps prompted by Mr. Brindle, this is actually an example of Mr. Alia trying to change his evidence. Then I say, but the instructions would have come from you, wouldn't they? Answer: it wouldn't have come from me, it would have come from a legal team in the bank. Question: I don't want to go into discussions with your lawyers. His Lordship, he's already told me that the position taken was on instructions from him. That's what I thought. So he did accept it, although it's right to say that this was another example of him trying to reverse tack in his evidence. Obviously hard to see how lawyers in Zurich are going to take a position otherwise than on instructions. So we were going to go to the AGBCs. It's worth just reminding oneself of the state of the documents both before and after. We've seen them a lot, but it's at tabs 12H1, 121 and 122. And starting with tab 121, as we all know, in the forms as they were sent back, one only had the typed name, the date and the signature.
Hang on a moment. 121A, we are.
Yes. Yeah. One had the typed name.
Sorry, just going back to that extract from the transcript.
Yes.
The document was returned to Dubai, was it? I mean, it's a bank Sarasin-Alpen document.
Yes.
So why were the bank's legal team in Zurich also dealing with it?
Well, what we were on was the Baker and Mackenzie. I'm sorry, I went too fast. What we were on was the Baker and Mackenzie letter, where they
Baker and Mackenzie were retained by
D1. It's entirely my fault, I went too fast. First defendant had retained Baker and Mackenzie.
Right.
And D2. Baker and Mackenzie had taken the position that the forms were filled in and signed by us.
Right.
I had asked this, that was a false position, and that was the position that was in danger of derailing our entire claim, but for the fact we had the forms and the post-it notes on, and we had them.
My question is only directed. Mr. Alia was saying, well, this is something that was being dealt with in Switzerland.
I think what he was talking about was, I think what he was saying is because it was a response to our letter before claim.
He was saying, my Lord, that Baker and Mackenzie were getting their instructions from the Swiss lawyers. He says that. Whether it was indirectly from him is something my own friend's making submissions about, but he says that was the means of communication to Baker and Mackenzie. That's why I asked that message to be read. This was very early days, long before my structured solicitors came on the scene.
So obviously the chain of lawyers.
So again, so Sarasin-Alpen had instructed Swiss lawyers.
Well, that's what appears to be being said. And the letter from Mr. Brindle seems to be confirming it.
Right.
My submission is that it was just a classic example of Mr. Alia evading and giving untrue evidence.
Anyway, sorry, I just couldn't quite see the connection between the first defendant and
Well, there isn't a natural.
Well, in the very early days of this, both Bank Saracen and Bank Sarasin-Alpen received the letter of complaint.
Yes.
And in the first instance, they employed Baker and McKenzie in Switzerland.
For each, that they, Baker McKenzie were retained by both.
But, yeah.
Okay, thank you.
But
It's
either
only
way,
fair to Mr. Walia, given the accusation was made, that point was made.
but either way, obviously, lawyers act on instructions, and Mr. Walia had confirmed.
Yes,
instructions came through.
it was only possible, that's all. Thank you.
So we're back on the forms.
Yes.
H1 121. As we now know, the names were filled in on page 1, but when we get to page 6 at the bottom, which is the first page of the Annex 1, there's no box ticked
Yeah.
in relation to Annex 1, and none of the material is filled in for the individual client analysis at Annex 1A that starts at page 9 and 10. And then in the filled in version, which is starts at 122, the box is ticked. We can see that at page 6381, but not by my clients. And the Annex 1A has been filled in. And
indeed, the document has been countersigned
the document's been countersigned, exactly.
on the same date.
Well, that was another of the points I cross-examined on.
Right.
That was one of the examples that we suggested showed a fairly careless approach on the Sarasin-Alpen side to backdating. I may come back to that if I have time. Now, paragraph 268 of the judgment summarises the errors on the forms that were completed. And one needs 268.
So I'm not sure I've actually read well, I've tried to read the manuscript entries. Do I need to have read them now, or is that? They're almost impossible to read.
They're set out
They may be set out in the
in the judgment.
Oh,
Exactly.
right, okay.
232. I'm grateful for that. 232. And one needs to perhaps have page 232 open. That's an easy place to look at it. And
Sorry.
then look at paragraph.
So I have to have page one?
Paragraph 232 open, so I can see what the points are, and then with a finger in that, then look at paragraphs 268 and 269 and 270 and 271, and the judge summarises the errors in respect of each of the forms, and essentially they are grotesquely wrong in virtually every respect. Perhaps most significantly, the statement that in respect of each of these three clients, there is an excess of $200 million in stocks, bonds and currencies. Mr. Khorafi confirmed that's not the case in his witness statement. And Mrs. Hamad confirmed in her witness statement at paragraph 32, which is recorded at 270, that the information in respect of her was completely wrong. And Mrs. Rifai, which is probably the most grotesque example of the financial status information being wrong, also explains her position at paragraph 271. And the judge accepted the evidence given on this aspect by the claimants, which you'll see that acceptance at paragraph 276. And my learned friend in his submissions
Yeah,
described...
Mr. Frindle rather said that the judge having grappled with the material as deployed in paragraph 273 and following. But you're probably coming to that.
That's the point I need to come back to
Right.
on the question of should they have qualified as
Right,
clients.
okay.
I think even Mr. Brindle isn't trying to suggest that those bits of information justified the material on the forms.
Right.
I think there's no suggestion that the material on the forms was accurate, and that's an impossible suggestion. The material on the forms was grossly inaccurate. This material comes back to the later question of should they have qualified as clients
Right.
anyway, which I'll come to. So what one actually has with the forms is a very alarmingly shoddy piece of box ticking, which just assumes or invents, or at the very least wildly exaggerates information about the defendants. Now, Mr. Tar...
But it also has the unfortunate appearance of having been written in the first person.
That's exactly
And my grandfather, my
yes.
CFO,
Yes.
and so on.
And again, one has to remember how this document was deployed by Baker and Mackenzie. We were facing a suggestion we had said all these things, because that's exactly what the document appears to suggest.
Right.
And it is in that respect a thoroughly deceptive document. And Mr. Taha gave evidence that he was not responsible for the false information that appears on these documents and its content. And that was not challenged, as the judge records at paragraphs 190 and 191. So it didn't come from Mr. Taha. It didn't come from the claimants, who were disavowing its accuracy. And in any event, no one at Sarasin-Alpen had ever met two of the claimants. Mr. Alia gave evidence that Mr. Nair must have ticked the box and filled it in on the basis of information from the claimants. But when he was tested on this area, it transpired this was all speculation and he had no basis for saying that at all. That is, I've already taken my laws to some of that transcript this morning, and that was explained and findings were made on that point in the judgment at paragraphs 188 and 189. And we've never had any other or better explanation. In relation to the third claimant, the evidence is recorded by the judge and his findings are recorded at paragraphs 214 and 15 and then 216 to 18. And as the judge records there again, wholly inaccurate information and no reliable explanation as to how it came to be prepared. And the judge rightly concluded at paragraph 218 that he could place no reliance on those forms. And where we were left then on the evidence was that an unknown person at Sarasin-Alpen had filled in grossly inaccurate and misleading information which was deceptive on the face of the form and which appeared to be wildly exaggerated. And the learned judge was entirely justified on this basis alone in reaching his conclusion that this was a deliberate failure to comply with the rules, which is his finding of paragraph 305 judgment.
To comply with which rule?
The client classification rules.
The need for determination.
Determination after analysis. Now, this wasn't, in fact, the only extent of the potentially relevant client classification material the judge looked at. What he, in fact, did, in total fairness to my learned friend's client, was conduct a painstaking analysis of the other material that the defendant said they relied on, which might have been relevant to client classification. These included client profiles which had been created in June by the first defendant, which the judge said held in paragraphs 94 and 95 were also inaccurate in material respects. And 94 and 95. Judge records at 95, satisfied in the evidence I have given which related to that information was incorrect in material respects. And I said the judge conducted a painstaking analysis. That is the analysis you see that starts at paragraph 243, where the judge says it's necessary, therefore, to consider whether Sarasin-Alpen can establish, on the basis of the other submissions advanced, that before accepting Mr. Khorafi and Mrs. Hamada's clients in June 2007, it had determined, and so on. And that analysis goes all the way through to paragraph 251, where he comprehensively analyses the information which Sarasin-Alpen might have tried to pray in aid. And then he summarised the position at paragraph 251 entirely fairly. And I would just invite my Lords to remind them, His Excellency, to remind themselves of paragraph 251. Then
that's the submission. Well, sorry, that's the Mr. Muhairi's.
Well, that his sort of boiling down, as it were, of what was being said. And just on that, before I go to the next paragraphs, one needs to keep in mind that the client profiles that are referred to are the ones he's already found inaccurate at paragraph 95, and one needs to also keep in mind that the research using publicly available sources has been dealt with at paragraph 250, which showed some very incomplete and limited information available from in a memorandum said to have been compiled from publicly available sources. The judge then, at paragraph 252, concluded he didn't get anything out of the discussions of Mr. Chirian that were relied on. And at paragraph 253, the judge addressed the cross-examination of Mr. Alia with regard to how Sarasin-Alpen could possibly have satisfied itself about the experience and understanding of Mrs. Hamad, who, and of course, as was clear from that, I invite my Lord to read it, but as is clear from it, from Mr. Walia's cross-examination, they were in real difficulties because they'd never met her.
Where was it said the determination was to be found? It's not in any document.
No,
And there's no record of the determination.
well, the primary case, I think their first case was it's still to be found in the AGBCs, even though they'd been filled in by Sarasin-Alpen. I think that was
even assuming they'd been filled in by the client. That is information upon which a determination could be made.
Yes.
So it can't be the determination.
No, I agree.
So, and I'm, of course, this may be pedantic, that there's a requirement to keep a record of the analysis of the determination. There isn't one.
Yes.
So where is the determination said to be found?
Well, it may be they would rely on the document called the client profile, which is the document which is the judge criticised at paragraph 95.
Right.
One of our submissions is the whole process was completely inadequate, and there was not a proper process and proper record keeping to show any proper process of determination.
Right.
My learned friend says, well, that's just a criticism of breach of 3, 2, 4, or 5 or 6 of the rules. But I say it's actually relevant to whether there was any analysis.
There's no complaint about 5 or 6, as I understand it, but
Yeah.
all I'm seeing is where does Mr. Walia say that, or when did the determination take place and in what form?
I don't want to put words into Mr. Wilder or Mr. Brindle's mouth, because my case was that it never happened and there wasn't one. And
Yeah.
my case and my submission was borne out by the evidence. And so in all those circumstances, the conclusion the judge reaches, which is at paragraph 254, was absolutely right. What the judge says is, in my view, Mr. Walia's evidence provides no basis upon which it could be held that before accepting Mr. Al-Khorafi and Mrs. Al-Hamad as clients in June 2007, Sarasin-Alpen had taken steps necessary to determine that they or either of them, 1, had at least 1 million in liquid assets, and 2, had sufficient financial experience and understanding to participate in financial markets. And that was a conclusion he reached after very careful analysis, and in fact being charitable in my submission to my learned friend's client about what information they could possibly pray in aid. And just to summarise 5 points that justify that conclusion. First, the most crucial document, the AGBCs, had been filled in after signature and with false and deceptive information. Secondly, my Lord's point, the information had been filled in the first person to give the impression the claimants were doing it. Thirdly, the client profiles were inaccurate in material respects, as the judge found in paragraph 95. Fourthly, the other information relied on was gone through by the judge and was obviously inadequate to establish any proper process of analysis or any satisfactory evidence of the wealth and experience qualification. Fifthly, in relation to C2, and I'll come to C3 in a minute, it was impossible to imagine, and Mr. Walia couldn't assist at all, how any view could ever have been reached or any process gone through to satisfy themselves that she had the experience and understanding. They had never met her. So that, in my submission, is an entirely sound finding. And the judge then, again, very carefully did the same exercise in relation to C3, which you see at paragraph 255, starts at paragraph 255, where the judge summarises Mr. Brindle's client's case. He made the point at 256 that, as he's held, they can't rely on the AGBCs. And then he very fairly went through the evidence at 257 and 258 and 259 to look at the other material, including the witness statement evidence at 258 and the cross-examination at 259. This was another instance where the client profile was inaccurate, and another instance where the defendants had never met the third claimant, just as they had never met the second claimant. And one needs to look at perhaps paragraph 259. When it was put to him there was no basis for Sarasin-Alpen to think that Mrs. Rifai had assets of 10 million Swiss francs, he answered that's not right. The information would have come from Alia. There is no information which the bank is dreaming up by itself. But he accepted in answer to the next question he was not in a position to know where the information had come from, Mr. Taha. When asked where the suggestion recorded that she had more than 200 million investments had come from, he answered, I wouldn't know. And so the judge's conclusion at paragraph 260, again in relation to her, reached after careful analysis and entirely right. No basis could be held that before accepting Mrs. Rifai as a client, Sarasin-Alpen had taken steps necessary to determine she had at least 1 million in liquid assets. Nor, so far as relevant, had Sarasin-Alpen taken steps to determine she had sufficient financial experience and understanding to participate in financial markets. And that consequence of that, as the judge explained at paragraphs 261 and 262, was that the claimants had to be treated as retail clients. And that meant Sarasin-Alpen couldn't do business with them at all, as the judge made clear at 262. Now, although not particularly critical to the judge's reasoning on this point, the judge did also express his concerns about a file note that was dated, this is the back dating, a file note dated 31st of May 2007 from Mr. Nair. And that's dealt with at paragraph 94 of the judgment. The judge's concern, which in my submission was well founded, was that the document referred to account numbers, but the account had not even been opened. Mr. Brindle went to the relevant part of the transcript of Mr. Walia's evidence in his opening submissions.
Yeah.
And my lords are going to be reading that again anyway. I'm not going to go back to it, but in my submission, the
Well, that's all along the lines that an account number would be on their normal practice tendered before the account is opened.
That's what he sort of ended up saying.
Yeah.
I'm going to invite my lords, when you look at it again, to look through what he actually said. What he actually says is a bit of a variety of explanations, which sort of ends up with the position as just summarised by my lord. But in my submission,
apart from what I call, I suppose, some aspect of credit, what's this backdating point go to?
well, my submission is it doesn't go to a huge amount, and indeed, even in the judgment, it doesn't go to a huge amount.
Right.
My learned friend makes a lot of it on this appeal, because what he's trying to say is all of the judge's findings are in some way infected by unfairness, and an example of this unfairness is his approach to the backdating. Well, that's completely wrong. You can see the judge's reasoning on all the key parts of the case, and they're nothing to do with, I find this because he backdated a document. But he does in fact find there's backdating, and in my submission the finding he makes, as it happens, is entirely fair and open to him. And when you read Mr. Walia's evidence, the transcript of his evidence, he did appear, and the judge in my submission rightly found, to be making it up as he went along.
Just give me the cross-reference from it.
Yeah, I knew you were going to ask you that.
D2, 53, I think.
I have a note in my notes to get it.
Thank you.
But we will get that. So as I say, it is a small point, although my learned friend tries to make a lot of it. But insofar as the point goes, the judge was justified on the material he had to disbelieve Mr. Walia. He appeared to be making it up, and it was a rather unconvincing explanation. And as I say, it's not the only example of curious dating in the documents, and we've just seen an example of that 6th of June date for the counter-signature on the AGBCs. So, well, that's the factual background and the judge's finding that the judge had not properly complied with their obligations. And against that background, I'll now address the grounds of appeal. The first point made related to whether Sarasin-Alpen could, contrary to the judge's finding, rely on the filled-in AGBCs, and the information in the AGBCs. And the judge's finding that he couldn't rely on them was entirely justified in my submission. It was not just that they were returned blank, although that was a very important point. It was also that they had been filled in a misleading way to suggest they'd been written by the claimants, and the information on them was itself incorrect and misleading, and there was no reliable explanation other than pure speculation about how the document came to be prepared or what the basis for the information was. And that's exactly what the judge has found, all of those points. And I'll give you the references. It's 188 to 191 and 214 to 8 of the judgment. And in relation to the misleading authoring, that's paragraph 304. In relation to the inaccurate information, it's judgment paragraph 276. Now, what...
I know Mr. Riddle doesn't like my noun, but it is a forgery, isn't it?
Well, I'd say so, yes.
Yes. It purports to be a document filled in by the person who signed it, when in fact it's been filled in by someone else.
Yes.
Yeah.
Well, yes. And the attempt to say, well, it's all an innocent explanation, the sort of thing that happens all the time, is really belied by the way in which the document was later used against us in those pre-action correspondence to say we had filled them in. Now, the technique on this appeal of my learned friend is to focus on paragraphs 234 and 235 of the judgment, as if that encapsulates the only part of the judge's reasoning. But what they've done is actually ignored the very extensive and careful analysis the judge in fact gave, which I've just been through in the judgment. And in relation to the AGBCs, what the judgment was saying in substance was that Saracen couldn't pull itself up by its bootstraps using false information on the form which some unidentified person had put in unexplained circumstances. Now, there's a very small point then made at paragraph 68 of my learned friend Skeleton, which I'm not sure he's pursuing, which is to the effect that the judge didn't explain the reasoning for his conclusion. That is, if it's pursued, a very strange reading of the judgment. It's a submission that one can only be made if one ignores paragraphs 188 to 191, 214 to 218, 267 to 276, and 304 of the judgment. The next point made is the criticism, which is renewed orally, essentially saying that the information, essentially criticising paragraph. Sorry, I'll start that again. The point made is that the information came from the claimant or Mr. Taha, and the judge is criticised for not addressing that or accepting that. But in fact, Mr. Taha denied it had come from him, as I said, and he wasn't cross-examined, and the judge addressed that at paragraphs 188 to 191 of his judgment. And as the judge also recorded there, Mr. Alia, in his cross-examination, in fact had no support for his speculation as to where the information on the forms had come from. So it's an unfair criticism of the judge. My learned friend also sought to say, and I think he rather downplayed it orally, that the information on the AGBCs was substantially correct. Well, it palpably wasn't. We've been to the forms. They were grossly incorrect. And the judge, as I say, set out the errors as listed in our evidence, which he accepted. So there's a submission of paragraph 69 of my learned friend's skeleton argument. You don't need to turn it up, but just for the transcript, all the criticisms made in that paragraph are entirely unfair and contrary to both the evidence and the judgment. The next point for my learned friend is a more technical point, which is that the contract in the AGBCs is a contract in the terms of the completed documents, even though the claimants didn't complete them. This is a sort of Alice in Wonderland submission, that the idea is that if the claimant signed them and sent them in blank, then whatever information Sarasin-Alpen chose to put in on the form represented the contractual binding form of the agreement between them. The proposition only needs to be said to be seen as absurd. I'm not going to spend any further time on that. My learned friend then made, in my submission, another bad point, which is also at paragraphs 70 and 74, 70 to 74 of his skeleton, that because the form as a whole was signed, this must have constituted a ticking of the box and a ticking of the correct box. So what's said is, I think the way it's put is, the other boxes are less likely to apply. So you've got to find the box that most likely is applying to them, and then deem that as ticked. But the judge considered that argument and rightly rejected it at paragraph 242 of the judgment.
Well, just remind me, would you, the judge's reason for holding that the document wasn't reconstrued as if box 1 had been ticked?
I think that's this is what he's dealing with at paragraph 242, as I understand it. What the judge says is, I reject the submission made on behalf of Sarasin-Alpen, but the fact that neither Mr. Khorafi nor Mr. Hamad ticked any of the boxes under paragraph 1 is irrelevant. In particular, I do not accept submission that on any view she was declaring by Annex 1 that he was a client by one of the definitions of client contained in COM. The true analysis is that in the circumstances signatory ticked none of the boxes under paragraph 1 of Annex A, he or she cannot be taken to have made any declaration under that paragraph 1. The position is the same insofar as Sarasin-Alpen seeks to rely on the declaration in paragraph 1 of Annex 1 of the AGBC's advice and submission set out in some paragraph 4 of the previous paragraphs. That's a bit Delphic. That is a reference to the separate independent consent requirement.
Yeah.
And what the judge says is Sarasin-Alpen can rely on paragraph 7 of Annex 1. And, my Lord, in these submissions, we say the judge got it right. If one picks up Annex 1, one can see that in relation to paragraph 1, there's a representation of warranty, definition of client, as follows. If that's left blank, even as a matter of construction, before you consider the regulatory framework, they're not making any identification of meeting any particular client box or client requirement. And it's not open for the recipient to say, well, you probably correspond best to one of these boxes and I'm going to tick that.
Well, not even if this is construed against the factual matrix, where both sides and an independent objective observer would know something about these clients.
I would know, because what one has to remember, this is part of a regulatory process of establishing, to help the firm conduct an analysis, of establishing what it is their qualifications and aspects of them are. You can't short-circuit it by saying, well, as long as you sign the form, I'm going to deem what I think on the matrix is the best box ticked, and I'm going to essentially bypass that part of the analysis process.
Well, that's a separate point, it seems to me, as to whether or not the document should be construed with a tick in the box. The fact that there's a tick in the box may not mean that the rule's been complied with, but I'm just dealing with your submission. But this can't be construed as having a tick in the box.
Well, my Lord, I accept that there's a regulatory aspect and a contractual aspect. In my submission, it probably isn't right to divorce the two entirely. When one's looking as a matter of construction at a document that is only there for a regulatory purpose, then you can't read someone saying, representing and warranting that they meet a definition as follows, without saying giving any further information about how they meet the definition, as being a declaration that they meet any particular definition. And you can't substitute for as follows some other persons, in this case the banks, guess what they meant by as follows. But what the judge is also finding, and we don't appeal, is at paragraph 7, they are consenting to being treated as a client. So in terms of the separate requirement under the rules of consent, they have signed this document, and that does contain their consent. One also, one needs to keep in mind...
Consent to being treated as a client if they are a client.
Well, yes, one needs to keep in mind that there are these separate limbs. They need to be classified as a client by the firm after the process of analysis, and they need to consent. The other point about my Lord Sir Richard Field's questions about the contract is it doesn't really take my learned friend anywhere, and this is the point I'm going to come back to on contractual estoppel. The obligation under the rules is on the firm to conduct a process of analysis and confirm that the client is indeed a client. You can't contractually short-circuit or bypass that obligation under the rules. So while there are these quite interesting debates before my Lord about whether Clause 1 as a matter of construction could be deemed a tick, or indeed whether contractual estoppel otherwise arises, that's all a bit of a moot, because it's not addressing what the judge has found, which is there's a regulatory obligation to conduct a process of analysis. That regulatory obligation was not complied with, and that's what gives rise to the obligation to give compensation. What we also say, a more minor point, is that rather than the non-ticking of the box being accepted by Sarasin-Alpen as deeming some form of ticking of the box, what in fact should have happened as a matter of practice and regulatory, what's obvious from a regulatory perspective, is the opposite. Alarm bell should have been rung. They should have said, look, these people who want to be, who profess to be, or who can only be qualified if they are not retail clients, have sent us back a form. They haven't even filled in the details. Chances are, being Arabic speakers, they haven't read it. We'd better meet them, meet all three of them, and make sure they qualify. Which is quite the opposite of the submission my learned friend is advancing on the basis of that form. So in my submission, you can't get there as a matter of construction or implication, but in any event, as I've just submitted, it all misses the point, which is this is a regulatory point which requires an analysis by the firm, and there's nothing here that assists in that analysis or can form a legitimate part of it. And the same goes to paragraph 7 of the form, which I'm coming to now, because my learned friend really repeats this submission by reference to paragraph 7, which he says is itself sufficient to qualify the claimants as clients. And that, again, in my submission just doesn't work. Again, the firm's analysis and verification process is independent of the client's consent under the rules. Paragraph 7, on its proper construction, only goes to the consent question, as the judge held at paragraph 242, and those are separate and cumulative requirements. And the reason for that is obvious, and indeed was explored in submission by my lords with Mr. Brindle, because otherwise every client, however poor and inexperienced, if foolish enough, would just self-certify by signature, and the firm wouldn't have any obligation at all. But that is the antithesis of what the rules provide for, which is a process of analysis and determination by the firm. So the firm has to undertake, on any view, an analysis under the rules, and as the judge found at paragraphs 254 and 261 of his judgment, they didn't do so. The conclusion of paragraph 261 is I conclude that Sarasin-Alpen failed to carry out any sufficient investigation in order to satisfy itself criteria were met. And also worth having in mind paragraph 325 of the judgment, where the judge comes back to the same point. And again, I'll just invite my audience to remind themselves of paragraph 325, especially the bottom half. Now that brings me to the contractual estoppel point at ground 2.2, which is a very similar point. It's first said the judge didn't deal with contractual estoppel, or he did. If my lords keep a finger in 325, because we're about to go through it. In fact, at 242, the judge does in fact address. I'm sorry, I didn't realise. Things have moved on. My learned friend accepts he did deal with it. So it's
Just with it in what looks like the wrong place, but nothing else.
yes. So it's in at 325. I also, as it happens, it's now a non-point. It's actually in there at 242 as well, in the right place. So it's in there. It's in there twice, but spelt out more fully at 325. The next point is. Well, the judge rightly makes the point in paragraph 325 that the rules don't permit a client to contract out, and as I just submitted, one needs an analysis, I've made the point that otherwise it would render otiose the first provisions of the rules, which specifically require analysis. You can't bypass the analysis requirement just by ticking the consent. So, to summarise on contractual estoppel, we really make 4 points. First, the firm has to determine, as a matter of principle, whether the client is indeed a client after analysis. And as a matter of principle, the firm cannot relieve itself of its regulatory obligation to do that. Secondly, the rules themselves require the determination and analysis process separately from the question of consent. You can only accept the client after analysis. Thirdly, on the facts, in any event, there couldn't be a contractual estoppel. None of them, in fact, contractually agreed that they qualified as a client, because the box was unticked and Annex 1 was blank. And as regards my learned friend's point on paragraph 7, consenting to being treated as a client, and indeed even as he relies, declare and further consent to being treated as a client, does not itself amount to a declaration for the purposes of contractual estoppel that they qualified as a client by meeting the wealth and experience test. That's not what the words say. It's difficult, in fact, to construe what the words say, but all they say is declare and further consent to being treated as a client under the laws and regulations of the IFC, and confirm I understand by making a mistake I should not be afforded the retail customer protection. So it has got the word declare in, which is a bit odd, but the rest of it is a fairly vanilla consent provision, and it's not making any declaration with regard to their qualification on wealth or their qualification on experience or understanding. The fourth point is that you don't, and I say you don't get this far, but if you did, one would not apply contractual estoppel in circumstances such as these, where the effect of the clause was not explained to them, and no one suggests it was, and where the clients were in fact retail investors and not clients for this wholesale jurisdiction, as the judge found in paragraph 325, and where they were financially unsophisticated and not given fair warning. Now, there is authority on that point, which we've referred to in paragraphs 275.6 and 275.7 of our skeleton, which is the Singaporean Court of Appeal. I'll give my lords a reference in a minute. I'm not going to take time on that now in terms of going to the authority, but essentially the proposition is that when one has consumer retail protection, one doesn't apply the principles of contractual estoppel in the harshest terms as perhaps might be said in the Springwell case. And we say that when my learned friend obviously relies heavily on Springwell, Springwell doesn't help him for three reasons. First, because there isn't a clear declaration to fountain estoppel, as I've explained. Secondly, because Springwell isn't addressing the retail consumer protection question. It wasn't a consumer protection case. The only cases that do address it are Singaporean Court of Appeal cases that I've referred to, and they are to be preferred. So the authority, yes. So it's one Court of Appeal case, one High Court. The authority is Volume 6, tabs 45 and 46. So this is my second point. The Court of Appeal in Singapore has rightly identified that consumer protection is an area where it would not be appropriate to apply the contractual estoppel doctrine. Thirdly, that's my most important point, none of this helps a learned friend because there's still a breach of the rules. And contractual estoppel doesn't mean there's no breach of the rules because they can't be contracted out of and they're a regulatory obligation. And the rules mean what they say, and they were breached in this case. And that's what the judgment and the compensation claim awarded feeds from. So, my Lord, there's nothing in my learned friend's arguments on those points. I think I've just made this point, so I'll pass over it. Yes, but one point, this is raised in paragraph 78.2 of my learned friend's skeleton, is that he suggests that we might be suggesting in some way that the investor and the information he gives on the form couldn't be one legitimate source of information for the firm to take into account. But of course that's right, that's what the form's there for, but it depends what the investor puts on the form. If the investor puts nothing on the form other than his signature, as in this case, it's not giving anything for the firm in terms of the information they need to conduct the client classification exercise. And the last point, I think, taken on this area by my learned friend is the suggestion that one doesn't need to be worried about the retail protection element for three reasons. First, he says, because the client isn't yet the client. Well, my Lord, that's an absurd proposition. This is about the process of determining whether he is going to qualify as a client and end up being stripped of the retail protections that he would otherwise have in a retail jurisdiction. So it is still protection for the retail consumer. That's what this is all about. Secondly, my learned friend says you don't need to worry because a wholesale client does get some protections. But again, the whole point of the client classification requirement is that the protections for a wholesale client, when there is not a retail client jurisdiction, are much more limited protections, excluding suitability and so on. So this is all about the more limited retail protections. You can't sweep the point away by saying you don't need to worry because there are some protections even for wholesale clients. The third point made is, and I learned a friend made this quite forcefully, he said, why protect people who have made a free choice? But the point of the rules is to require not only a consent requirement, but a policing of the consent requirement. And that is why one has the analysis after determination. So free choice and consent are not the point. That is just one of the three of the cumulative requirements, and it's obvious why. My learned friend then, in relation to that last point, did make some arguments which didn't really take us anywhere about what the consent requirement was all about, and he suggested it was in some way to be seen as an opt-out. It was related to an option of being treated as a retail client if you're a wholesale client. Now, this all was a little bit in reverse because the option of being a wholesale client or a retail client didn't arise till later, when the DIFC became a retail as well as a wholesale jurisdiction. And it's right to say that under the new rules, now that there are both jurisdictions, both formats here, there is an opt-out, so even a wholesale client can elect to be a retail client. But that doesn't arise in relation to these rules, because the retail option hadn't yet come in. So what my learned friend, although the submission very elegantly put, but what they actually came down to is this is just a consent requirement. If you don't consent, you can't be a client, which is exactly what the rules say. So there's nothing, you can't sort of downplay or relegate the consent point as being some kind of option. It is a requirement of consent, which is just means what it says. My learned friend then had what he called his ground 2.3, which is his alleged error of law in Mrs. Al-Rifai's client classification. And that was in their skeleton at paragraph 81, dealt with in our skeleton at paragraphs 276 to 280. There isn't really a point here. I probably need to come back to this, but the judge in fact decided that the advice given to Mrs. Al-Rifai was specific advice, and he also decided that she did not have 1 million in liquid assets. So I'll come back to that one, but there's nothing in that ground. Then there was ground 2.4, which is my learned friend's big attack on the learned judge's findings that they were not clients. And this obviously arises because the learned judge rightly held that it wasn't enough for us to get home if we established they hadn't properly classified them as clients, if in fact they would have qualified as clients. Otherwise it's a technical breach with no causative consequence. And that's the judge's approach. So the critical to that was his follow-up conclusions that the clients wouldn't have qualified. My clients would not have qualified as clients for regulatory purposes. Now, on that point, my learned friend started off.
What point you're now on? You're now on whether they would have qualified.
Whether they would have qualified. And my learned friend essentially says the judge was wrong to say that they wouldn't have qualified. Now, the first point my learned friend makes is that the judge applied the wrong test. What he says is the judge was considering the claimant's experience in these types of investment rather than the claimant's experience and understanding of financial markets generally. And this is the point we've already spent some time on this morning. In fact, even if my learned friend were right about the test, he's not right about the judgment, because it's a misreading of the judgment. What the judge, in fact, decided was that the claimants were inexperienced investors generally. We've cited in paragraph 283 of our skeleton argument all the relevant passages of the judgment. And in addition to those passages, one needs to look at all of paragraphs 272 to 276 of the judgment. Where the judge considered carefully the evidence to the effect that none of the claimants were experienced in financial markets and that Mrs. Al-Hamad and Mrs. Al-Rifai were inexperienced investors. And one can see him conducting that exercise from 272 through 274, 275 before accepting the evidence at 276 and reaching his conclusion at 276. I probably should have given you the start passage from that. It was actually 267. I should have said 267 through to 276. So what the judge, in fact, finds is they are inexperienced investors. Mr. Al-Khorafi did not have significant experience in financial markets, Mrs. Al-Hamad and Mrs. Rifai were inexperienced investors. And that's the summary at 272, which is accepted essentially at paragraph 276. So even on my learned friend's test, he doesn't get home because the judge actually found they were simply inexperienced investors in the financial markets. But in any event, he was applying the wrong test because my learned friends are ignoring Conduct of Business Rules 3.2.4, which we went to this morning, which do make it clear in my submission, but on any view, one needs to be considering relevant financial markets, including those relevant to the proposed transaction. And there's also the point, it's perhaps a more minor point, but it is still a significant point, raised by my Lord Sir Richard Field, that even looking at the first rule of COB, 3.2.2, they have to have understanding such as to enable them to participate in the financial markets, which is again a relevant part of the consideration. So, well, that's the attack on the qualification of the clients. There's then a pedantic point in my submission about whether the judge inserted a necessary steps test. There's 2 points about whether the judge did insert a necessary steps. First, it's a perfectly sensible description for the judge to say we didn't take any necessary steps to determine or to analyse is a perfectly sensible description of what is required under the rules, which is a process of analysis and determination. So there's nothing in that point. But secondly, what the judge found, and it's clear at paragraph 261 of the judgment, is that the firm did not undertake any sufficient investigation. He found that it wasn't a process of investigation. So my learned friend necessary steps point doesn't get him anywhere, because the judge made it quite clear that even without inserting the words necessary steps, they just didn't undertake the investigation. So, I mean, putting that point another way, if you just ask the question in the terms of the rules, did the firm determine after analysis that the clients met the wealth qualification and experience understanding qualification? Judge's findings are as he found. They didn't comply with that rule. And on this aspect, my learned friend's submissions are a little Delphic, because I think he recognises, or if I submit, he recognises how unattractive his submission is. What he's saying, or close to saying, is that as long as the firm says they're clients, determines they're clients, says they are, then you've done your process of determination and analysis for the purposes of the rules, which again is one of these self-fulfilling ideas, self-certifying ideas, which is absurd. What the rules are telling you to do is to do a process of an actual process of determination and analysis. And I know a friend can't say, well, it can be as vestigial and hopeless as the firm likes, as long as it just says at the end of whatever it is, yes, they're a client. And the other point about that submission from my learned friend is it sits badly with his own case at trial, which was accepted by the judge, that there's no contractual duty of care on the firm's part, essentially in line with the regulations. We submitted that as well as being a regulatory duty, there was a contractual duty of care which matched the regulatory duty. So there was a duty in contract to comply with the rules. It was slightly unnecessary submission because we had the regulatory entitlement anyway, but we did submit that. And that was rejected on the basis that you don't need it because, and in line with my learned friend's arguments, you don't need it because you've got the regulatory duty and the regulatory protection anyway. So that being their case, it's quite surprising to see the submission that on something like the client classification, you don't need any actual process of analysis or determination at all, because once you've said they're a client, that somehow complies with 3.2.2. What's obviously required is a meaningful, substantive process of analysis, and the judge has found that didn't happen. Then the next point for my learned friend is a short point. He suggested that there'd been some conflation by the judge with rules 3.25 and 3.26, which is verification of record keeping. Well, the rules are related, but the judge didn't conflate them. He was clearly addressing in his judgment whether the firm had made a determination after analysis, and his finding was that the firm had not, and that's dealt with in paragraph 290 of our skeleton. The next point relates to the fact that the claimants had never met the clients. I'll start again. The defendants had never met my clients, which the judge rightly described as a striking feature of the case, and that's paragraph 163 of the judgment. My learned friend tries to attack that, but there's a few points that arise in relation to his attack on that. First, while Mr. Khorafi was said to be the agent of the first and second claimant, there were no powers of attorney in favour of the first defendant in this case, which is an important consideration. And as one of the interventions from the judge that we saw yesterday in the transcripts made clear, the books are full of examples of children deceiving their parents. Not that this is this case, but one needs to test it against what their obligations are. And the agent cannot cloak himself with authority. Secondly, and this is the more important point, even assuming Mr. Khorafi were in some respects an agent, he couldn't possibly have been an agent for the purposes of the firm establishing its client classification process. The firm couldn't look at Mr. Khorafi's wealth or understanding. They needed to establish the experience and understanding of the clients. The clients are always the clients. So the agency argument doesn't help my learned friend. And it was on this point that my learned friend referred to the Zaid or Zaki case. And this was, of course, a very different case. This was a case not about client classification, but about suitability. And more crucially, this was a case about a joint account on which the family members had been named for succession purposes. Just for your note, it's at paragraphs 19 and 20 of the Zaki judgment. What is said, volume 3, tab 22. Volume 3, tab 22.
Volume 3.
Tab 22. So that's the Court of Appeal, which is, I think, worth keeping open, but I meant, in fact, to take it to the other one. So keep that open, but also take up bundle volume 4, if you would, paragraph 25. So tab 25. And then... Well, I apologise for that. It's volume 3, tab 19. I'm grateful to my old friend, Mr. Brindle. Yes, it's volume 3, tab 19, paragraphs 19 and 20, which is at 860, 861 of the bundle. So the critical point is paragraph 20. In September 2003, Mr. Zaid opened a joint account with Credit Suisse, Geneva. The account was in the name not only of Mr. Zaid but also the claimants. Mrs. Zaki accepts this was done at least in part for succession purposes. A daughter reluctant to accept this, in circumstances where the family had no involvement in the operating account. it seems likely the family were named as account holders for succession purposes. So that's the critical point there. And then going forward to paragraph 29 of the judgment. What the judge holds is these agreements were, as I have said, not only of Mr. Zai, but also of his wife and daughters. But it is clear that Mr. Zaki dealt only with Mr. Zai. At no stage did his wife and daughters assert a right to be consulted. They must have been aware that Mr. Zaki dealt only with Mr. Zai. They must therefore have let Mr. Zaki understand they consented to dealing with Mr. Zai. Nevertheless, they remained clients of CSUK to whom regulatory duties were owed. If insofar as CSUK had a duty to ensure that recommendations of clients were suitable, but duty was owed to each of the claimants. However, so that's the first point, it's about suitability. However, because Mr. Zai's wife and daughters allowed Mr. Zai to deal with Mr. Zaki on their behalf in every respect, I do not consider they can assert that what was suitable for him was not suitable for them. Again, that's the critical point. And then one can read the rest of the paragraph. And so one can exactly see why this is a perfectly sensible reasoning in that case. If you've got a joint account, then although, and one person who is a joint signatory gives instructions on the account, then although there's a duty of suitability owed to both clients, on a joint account, one can't really do otherwise than say what's suitable for the joint signatory who's calling all the shots is suitable for both of them. That logic just doesn't work at all on this case.
If the mother and the wife had left it to the first claimant to deal with the whole matter of qualifying of clients, including the provision of information as to their particular circumstances, would the first defendant have been entitled to receive such information as it may have obtained from the first claimant in respect of all three?
It's hard to see how they could. I'm not sure I'd go so far as to suggest it would be impossible to construct a scenario. It's very hard to see how you could establish a client's financial understanding and experience, perhaps experience, certainly not financial understanding, without meeting them. I think at the very
least...
least...
There's not a sort of cultural element here where in Middle Eastern society the expectation would be that the son would handle these matters on behalf of his mother and his wife, and they would accept that he would be, in effect, their mouthpiece.
Well, that is absolutely not right. That is the submission that my learned friend tried to advance, which got nowhere at trial. He didn't, in fact, pursue it at trial. And we were interested to see it come back.
Well, my learned friend says I didn't pursue it.
Well, it didn't, but it got rather squashed in the course of the trial. The problem was, it's just not how business is done here. Mrs. Al-Rifai and Mrs. Al-Hamad have other banks, as in fact, my learned friend's point, Credit Suisse and so on. They all meet the clients. There's no question of them not having contact and meeting and having direct communication with your banker. So there's no evidence of any practice, and the evidence was against there being any practice that you do not meet the women folk because we're here in the Middle East. So in answer to my Lord's first question, I suppose it's possible you could imagine a scenario of somehow communicating their experience and understanding in a way that you could verify had come from them directly and wasn't just the agent sort of saying it of his own accord in a way that couldn't be relied on. But it's extremely difficult to imagine any client classification process where they are not meeting the clients. And certainly in this case, one is a million miles away from having any basis to ascertain the wealth and the understanding and the experience qualifications of Mrs. Al-Rifai and Mrs. Al-Hamad. And obviously the proof of the pudding's in the eating, because you can see what they said about their experience and their wealth, and it was just wildly, wildly inaccurate. Yes, my learned Julia reminds me of paragraph 163 of the judgment, where it's actually on the point I'm on, where the judge says it's a striking feature of the case that neither of them ever met Mr. Wally or Mr. Nair. Both Mrs. Hamad and Mrs. Rifai presented intelligent, educated and emancipated women, well able to make their own decisions, rejecting suggestion over not without any question decision taken by Mrs. Khorafi in relation to their financial affairs, and so on. And it's also worth, on that point, picking up but at D2, day 5, page 77, sorry, it's tab 55, page 77, 78. Because I explored this issue with Mr. Wally, and I was interested to see what he said. I said, starting at line 8, there was no reason at all for you not to have met either Mrs. Hamad or Mrs. Rifai, was there? I'm sorry, there was a question. No reason not to have met her or even spoken to her. No, like I said, in this part of the world, having lived in the Middle East for more than 20 odd years, and having dealt with the for the reason of similar size photography, I've not met anybody's woman folk, should we say, mostly 99% not. Question, that seems to be an assumption that you made on your case. I may have said part, but certainly the case. But you had no reason to believe that in this case, with these clients, any cultural sensitivity would prevent you from meeting her. Like I said, having dealt with a number of Arab clients, we don't ask. It's not the right thing to do. If somebody wants to meet us, they would meet us, but we don't ask. I'm sorry, that's the reality of life here. Question, you didn't make any inquiries whether there would have been any cultural issues in meeting her. Answer, no, I did not. We have all seen Mrs. Hamad, and it's quite obvious that you wouldn't have been any problem in meeting her, would there? Correct. Indeed, her other banking advisors did meet her, correct. So no cultural issue at all for you not to have met her in relation to this enormous investment. No, I completely agree with you. I'm sorry, yes, but I don't know what to be to read on. Well, where do we read?
Down to about line 21 on page 79, please.
Well, can I just invite you to read on to lines 20, down to line 21 on page 79. And now obviously we're ready for transcript.
Well, I think we probably cut it short and just go to line 12 of page 79, question and answer there. Seemed to be saying it's all right to have Mr. Khorafi just acting informally without any power of attorney. No, I'm not saying that. That's what he was doing. That's what we were accepting. He's the son, she's the mother. It's like me. I've been active for my mother for the last 30 odd years. I don't have a power of attorney, but I'll do what is correct for her and what is not. I'll run her bank accounts. My father died 30 years ago.
So that passage in fact shows, it's another example, leaving aside the quality of Mr. Wiley's evidence, what it showed was at the very best just some sort of speculation or assumption on their part and no basis for not meeting the client, as indeed Mr. Wiley accepted that passage. My Lord, I'm conscious this is quite dense stuff. I wonder if it's perhaps a convenient moment to take a break.
Yes. Thank you. We'll take a break.
All rise.